Hey everybody, how's it going? Welcome back to Copper Jacket TV. So the new concealed carry law in New York, which is known as the CCIA or Concealed Carry Improvement Act, starts tomorrow, September 1st, 2022. Now the GOA has asked a judge for an injunction in this case to try and stop that new law from being implemented. And today I want to give you an update as to what's going on with that injunction. So let's get to it. Real quick, before we continue, I want to thank you all very much for watching these videos. If you haven't done so already, please hit that subscribe button and check out the main sponsor of this channel, which is linked down below, the USCCA. With your USCCA membership, you get things like self-defense liability insurance, you get online training, education, a national reciprocity map, and so many other cool things that it makes it absolutely worth it. Definitely check out the USCCA below. So the case that we're going to be talking about today that challenges the Concealed Carry Improvement Act is going to be, and please forgive me if I mispronounce this name, Antonyuk V. Bruen. So it's Antonyuk, the GOA NY, and the GOF v. Bruen. So they're going after this particular law. They've asked a judge for an injunction. Now, they filed this case on July 11th, 2022. And believe it or not, movement has been quick on this one. Usually when you follow these things, you know, things happen in periods of months, 6 months or years, right? When you look down at what's happened since it was filed. In this one, something has happened just about every single day. Now, the first big movement that we had in this case was July 20th, where the GOA, GOF, and GOA NY and Mr. Antonyuk filed a motion for a preliminary injunction to stop this law from taking effect on September 1st. Now, the court gave Bruen until August 10th to respond. Now, Bruen asked for an extension. He said that he needed more time to come up with, all of the relevant data so that he could, properly argue his case. And the court, the judge, actually denied that extension, saying that if he did that, there wouldn't be enough time to get all of these steps done before the law actually took effect on the 1st. Now, I'm going to put this next one up on the screen. I'm going to read it directly from here so I don't get anything wrong. But this is the judge's response to New York's request for an extension. Now, I should also mention that the judge actually references the recent concealed carry case that was in front of the Supreme Court, which was NYS RPA v. Bruen, stating that Bruen should already have all of the information that he needs in this case because of that Supreme Court case. So everything has already been compiled by Bruen. He has everything he needs to make his argument because they were just in front of the Supreme Court. And so what else would you possibly need to gather to undertake another case of CCW? Everything should already be there, and the judge actually acknowledges that. So let me go ahead and put this up on the screen so you guys can read it as well. Text order, granting in part and denying in part 10 defendant's letter motion for an extension of the deadline by which he must respond to plaintiff's motion for a preliminary injunction. Although defendant, and this is going to be the defendant is Bruen, certainly must, as he argues, review extensive history to brief the court on the relevant history traditions in his response, he has already gotten a head start in amassing the necessary historical sources in the NYS RPA Association Inc. v. Bruen. Moreover, although the plaintiff did not also file a motion for emergency relief in the form of a temporary restraining order, the law they challenged does take effect on September 1st, 2022. Court could not grant defendant's full extension he seeks without shortening the 7-day, the 7-day period for plaintiffs, 2, time afforded to the court to review that reply before the hearing, 3, the window of time in which to hold the hearing, and 4, the time afforded the court between the hearing and September 1st, 2022 to prepare a decision and order. In short, the complete relief that defendant seeks in this letter motion would deprive plaintiffs of their right to have their motion for a preliminary injunction fairly and justly decided. Now, there's more to that order, but it basically states that instead of the 10th, he's giving Bruen to the 15th in order to, file his response. But really, there was a lot of fairness to Mr. Antonyuk, and there was a lot of signaling that the judge might actually go ahead with the injunction. But if you scroll all the way down to the bottom of everything that's happened here, the last thing to happen was on August the 25th, where the GOA and Mr. Antonyuk asked for a copy of the transcript. Since then, I don't see any movement whatsoever. So the judge had almost implied that he was willing to grant the injunction prior to the 1st, and now we have nothing. Tomorrow is the day when this new law takes effect, and so far, no injunction. And this injunction has to happen before tomorrow, or it will take effect tomorrow. And so we need this injunction to happen, or else everybody in New York that has a permit is basically going to be out. Now, in this particular case, Mr. Antonyuk actually said that he plans on defying some of this law, stating that he goes to the gas station, he goes to the grocery store, he does these things that he does on a daily basis, and private businesses are now considered these, safe zones where he won't be able to carry. And so his rights have been restricted even more than they were. So, I mean, if we put the people who want to get a permit to the side for now and just talk about the people that already have permits, the people that have had permits and possibly had permits for years, never even got a speeding ticket, these people have essentially lost their rights as of tomorrow. The new people don't even have a way to essentially get a permit because of all the confusion. There's so much confusion around exactly what the training is, what the requirements are, who can do the training, the good moral character thing. That's up for debate between each individual person, because good moral character is something that is not really defined very well. And so if somebody sees something, maybe just like a flag or something like that, they may deem, well, if you have that flag, then you might not be of good moral character, and then your application is gone. It's all up to interpretation. So the interpretation of the person who is actually conducting the investigation, if that person thinks you're not of good moral character, then you don't even get to get started with the CCW process. So again, it is going to take away rights from people that already had their permits. It's essentially not allowing people to get new permits because there's just so many loopholes, so many pitfalls that you could face in this, and there's not really a good process of actually getting one anyway. I mean, people are confused. Law enforcement is confused. Sheriffs are confused. I mean, people are confused up and down the board as to how this is supposed to be implemented. So Bruen was supposed to expand on, well, not even expand. These are rights that already existed that New York had taken away. So they're trying to give some relief to New York in terms of their Second Amendment rights. And this basically just takes them back to the Dark Ages again, and puts them in a place where they're not able to exercise what we now know from the Supreme Court, even though we all knew this beforehand, right? But what's now been guaranteed, I guess, by the Supreme Court is that we have a right to carry for defense outside the home. New York is taking that away once again. So hopefully we'll see an injunction. If something happens later on today, I'll definitely bring it to you. Thank you all very much for watching. I do appreciate it. Please like, subscribe. You guys have a great day.